Hey guys! Welcome to Couple. Please like and subscribe if you like this video. Judge Raymond Kethledge is a committed originalist and textualist, which means he shows no favoritism to either side in any case, and instead applies the law as it is written. Judge Kethledge uses this sound approach to judging, the same approach used by Justices Antonin Scalia and Neil Gorsuch in every case that comes before him. Judge Kethledge has also criticized judicial activism, which is when judges insert their own policy views into their decisions rather than applying our laws and Constitution as they were written and understood at the time they were enacted. Advertisement. Importantly, when faced with questions involving immigration law, Judge Kethledge takes the same approach he takes in every other case. He faithfully interprets and applies the laws as written and adopted by the politically accountable branches. And if those laws are not as stringent as some may prefer, it speaks to the need to address the laws themselves, a need that must be addressed by the legislative and executive branches, not the judiciary. Advertisement. Judge Kethledge has adjudicated nearly 120 immigration cases during his decade on the Sixth Circuit. In every one, Judge Kethledge applied the same rigorous textualism he applies in every case that requires statutory interpretation. And that approach required him to affirm the Board of Immigration Appeals in 97% of those cases. Interpreting and applying immigration laws faithfully sometimes means upholding the removal of immigrants despite compelling or even heart-wrenching personal stories. In these cases, too, Judge Kethledge understands that his job is to follow the law, not to decide which side deserves more empathy. That is what a good judge should do. In Mora v. Holder, for example, Judge Kethledge confronted an immigrant who had entered the United States at age 14 and overstayed his visa, but then went on to be a productive member of the community for 16 years. Judge Kethledge remarked that, were the man a citizen, we would call him a Model 1. But Judge Kethledge nonetheless recognized that the law did not allow the court to grant the requested relief and therefore ruled for the government. Similarly, in BA v. Holder, the record strongly suggested that the immigrant had been subjected to mutilation in her home country. But the immigrant, who claimed that her original immigration attorney was deficient, failed to file a motion to reopen her removal proceedings within 90 days of the entry of her final order of removal, as required by the Immigration and Nationality Act. As a result, Judge Kethledge concluded, the courts had no lawful basis to grant her relief.